Good afternoon, everyone. Today I'm going to talk about a legal principle called frustration of contract. In simple terms, frustration of contract happens when two parties make a valid agreement, but after the contract is formed, an unexpected event occurs that make it impossible to perform the contract or change the obligation so much that it would be unfair to hold the parties responsible. The law recognizes that sometimes things happen outside everyone's control, and it would be unjust to force someone to complete a contract under such circumstances. Frustration exists to ensure fairness when the unexpected make a contract impossible or radically different from what was agreed. A few key points to understand about the frustration of contract. First, there must be a valid contract between the parties. This means that both parties initially agreed to the term and intended to perform their obligations. Second, an unforeseen event must occur after the contract has been formed. This law only considers events that neither party caused and that could not have been responsibly anticipated when the contract was made. Third, the events must make performance either impossible or fundamentally different from what was originally agreed. It not enough for the event to make the contract inconvenient or more expensive. It must truly change the nature of the contract. Example of frustration event could include natural disaster like flood or earthquake, sudden government restriction, or even the unexpected loss of something essential to performing the contract. The key is that the event is outside the control of both parties. To make this more concrete, let me give you an example. Imagine you hire a hall for a wedding reception on a specific date. Everything is agreed and both parties are ready. But a few days before the wedding, a severe flood destroyed the hall. Now it is impossible to hold the wedding at that location. Since neither the person who booked the hall nor the hall owner caused the flood, the contract is considered frustrated. The law will release both parties from their obligation fairly. Here another example. Suppose you hire a musician to perform at a birthday party. A day before the event, the musician becomes sick and cannot perform. Again, the performance is impossible and the contract is frustrated, being both parties are free from the legal responsibility. This example shows how frustration of contract protect party when unexpected event make performance impossible or radically different without blaming everyone. In conclusion, frustration of contract is an important legal principle that ensures fairness. It allows parties to be released from the obligation when unforeseen events make performance impossible or fundamentally different from what was agreed. This principle helps maintain justice and balance in contractual relationship. Thank you for listening.